Hello, hi, welcome everyone. Thank you for joining us this evening for our webinar on changes to the EUSS settlement scheme. We will wait a few more minutes for more people to join. This has been one of our most subscribed events to date, with over 500 people registering to take part. So we'll give it a few more minutes. As I can see, people are still logging on. Hello and welcome everyone. We are also live on Facebook tonight, and we will be taking questions from both Facebook and Zoom. We are just giving it a few more minutes for to allow more people to join, and we'll get started. While we are waiting, I'd like to invite you to introduce yourself in the chat if you'd like to, and you can tell us your name, whereabouts in the UK you're joining us from tonight, as well as your nationality if you'd like to. I'm Andrea Dumitrache. I'm co-director of the 3 Million, and I'm joining tonight from Bristol. I'm Romanian. I've lived in the UK for about 12 years, and I'm really excited to see so many of you joining us tonight, as we're going to go through the details of an issue that we've been raising the 3 Million for years. So as you might know already, we are a grassroots group representing EU citizens and family members living in the UK. And our work ranges from organizing and mobilizing EU citizens communities to informing you about rights and holding the government to account. So tonight, we are focusing on changes to the EU settlement scheme that come as a repercussion of a legal case brought by the Independent Monitoring Authority against the government in relation to pre-settled status holders. And we will be talking about the repercussions of this court case, as well as the way that the Home Office is implementing this decision. So you have an opportunity tonight to ask your questions from our immigration experts. We would like to ask you to use the Q&A function to add your questions throughout the webinar, and panel members will answer as many of them as possible tonight. But please don't use the chat function to ask your questions, as we won't be monitoring this. So you can find the Q&A function at the bottom of the Zoom screen. If you are watching us on Facebook Live, you can put your question in a comment, and we'll try to address as many as possible. But we might not be able to get through all of them. If you have any outstanding questions at the end of the event, you can get in touch with us through our website. And you can also find information there about your rights and about the judgment specifically. We have produced a Q&A document which covers answers to the most frequently asked questions about the High Court decision. And you can find links to this, as well as on how to contact us, in the chat. Do keep in mind that at the 3 Million, we cannot give individual legal advice. And we do recommend that you get in touch with a qualified immigration advisor or lawyer who can answer your question fully, depending on your individual circumstances. As you'll hear tonight as well, there are still a lot of unknowns about the implementation of this judgment. So we are sharing what's been made public and the outstanding questions that we have ourselves as well. Last but not least, we are recording tonight's webinar and we will be sharing the video with you after the event. So do please share this with your friends and family and anyone who you think might benefit as well. So without any further ado, I'd like to ask the panel to introduce themselves and the organizations that they represent as well. So, Rhys and Pam, shall we start with you?
Yeah, thanks, Andrea. Happy to go first. My name is Rhys Davis. I am General Counsel at the IMA, so I head up the legal directorate at the IMA.
And my name's Pam Everett. I'm the Operational Delivery Director at the IMA. So my teams are responsible, amongst other things, for engagement with relevant public authorities, the Home Office in this case, on matters that we are investigating.
Great, thank you. Chris, would you like to introduce yourself?
Yeah, thanks, Andrea. Good evening, everyone. My name is Chris Benn. I'm an immigration lawyer with a firm called Seraphus, and I specialise in the EU settlement scheme and the working on the issues to do with citizens' rights following Brexit.
Kezia.
Hi, my name is Kezia Tobin. I'm an immigration lawyer and I am the head of policy and advocacy at the 3 Million, joining you from Geneva this evening.
Thank you everyone. So first of all, we'd like to point out that the changes that we are addressing today were announced on 17th of July through the changes to the immigration rules and also a press release by the Immigration Minister, Robert Jendrik. But in addition to these that are to do with pre-settled status holders, in the same announcement, we heard about other relevant changes to the EU settlement scheme as well. So Kezia, can you tell us what those changes are and what's been updated when it comes to especially people submitting late applications?
Sure, thanks Andrea. Yeah, there have been several changes that were introduced through this statement of changes beyond the extension of pre-settled status by 2 years and the automatic upgrade to settled status, which I know are the two issues that have brought most of you here this evening probably. So I'll keep it fairly brief, but I think it's important just to touch on what some of the other changes have been in case they are still of relevance to some of you or to people that you know or represent, because I know we've got some immigration advisors here on the call as well. The main one, as Andrea's already identified, relates to late applications. So the Home Office, as a little bit of background, the Home Office provided an extra 6 months beyond the end of the transition period in which people were able to make applications to the EU settlement scheme. And that's known as the grace period. And it came to an end on the 30th of June, 2021. But as many of you will be aware, the settlement scheme has remained open and still is open to those who didn't apply by that date, who were in the UK, who are late applicants. Now, joining family members who've come into the UK since then don't count as late applicants unless they're applying more than 3 months beyond the point at which they entered the UK with an EUSS family permit. Now, until this statement of changes was issued, late applicants needed to provide reasonable grounds to explain why their applications were late, and the assessment of whether or not the grounds they provided were reasonable was considered as part of the kind of broader eligibility criteria, meaning that those people who made their applications late would still be issued with certificates of application, which confer all rights that having status under the EUSS would. So the right to work, for example, being a very significant one. And those certificates of application would be issued before the Home Office went on to consider whether the person's application would succeed because they were eligible. And in this statement of changes, that has altered. So the reasons why applications are being made late have now, the consideration of those reasons has now been moved into what's called the validity part of the consideration process. And what that means is that if the reasons for a late application are deemed not reasonable, the application will be rejected as invalid rather than refused. Now, this concerns us a lot because it will affect a lot of people. There are still consistently around 60,000 late applications each quarter, and that equates to about 650 late applications each day. So it's a lot of people that this concerns. And those people now won't be issued with a certificate of application until the Home Office has carried out an assessment about whether or not there are reasonable grounds for the late application. Significantly, those people are also not going to be given a right of administrative review or a right of appeal as a way of challenging the rejection on validity grounds. Now, the Home Office has said that the reason is to deter spurious applications, but given the numbers of applications, we're very concerned that this is going to affect everyone, including the many genuine applicants out there as well. And when the Home Office considers validity, they don't go back to people and ask them to submit further evidence to help them decide whether or not. So in this case now, people are not going to be given the opportunity to provide further evidence to help the Home Office decide whether or not the delay has been justified. Whereas when they were considering it as an eligibility point, people would have been contacted. So that's another concern that we have. And we're told that the guidance about what constitutes valid reasons is going to be updated, but it hasn't been just yet. So that's something to watch. And another change that was introduced through the statement of changes regarding validity criteria relates to in-country applications from joining family members. So from the 9th of August next week, people who've come into the UK as joining family members won't be able to apply to the EUSS. Their applications will be deemed invalid if they're assessed as being illegal entrants. Now, we've been reassured that that won't include people who came in as visitors, but anyone else who's deemed an illegal entrant won't have their application substantively considered. And just lastly, a couple of other points. There are 2 routes that are now closing on the 8th of August, and they are routes to what are known as Zambrano applicants and Surinder Singh applicants. And just without going into it in too much detail, Surinder Singh applicants is the label that's been given to the family members of British citizens who were living and exercising treaty rights in another EU member state before the end of the transition period, who on return to the UK have brought those family members with them and on the basis of having exercised treaty rights. So that route is now closing. And Zambrano applicants is the label that's been given to the non-EU national carers of British children who were deemed to have treaty rights in the UK. So that route's also going to be closed from the 8th of August. And last but not least, under the dependent relative category, that is being extended. The definition of dependent relatives is being extended to include adult children of durable partners. And it also means that minors who obtained pre-settled status before they turned 18 but have since turned 18 will still be eligible to apply for settled status. So those are some of the other changes, and I'll leave it there now. Thank you, Andrea.
Thank you, Kezia. So we've mentioned in regards to changes to pre-settled status that these have come from a court case brought by the Independent Monitoring Authority with interventions from both ourselves at the 3 million and the European Commission as well. So Rhys and Pam, could you talk us through the court case and what the High Court found in relation to pre-settled status holders?
Yeah, of course. Thank you, Andrea. I will briefly talk through how we got here in terms of the case and the judgment before then passing on to Pam, who will talk a bit more about what's been happening since the judgment and what the IMA has been doing and our early impressions of the proposal. So if we go back a bit to over 2 years ago now, where the court case originated from, and essentially we had concerns regarding an element of the EU settlement scheme, which in essence provided that those with pre-settled status, so holders of pre-settled status, would lose their rights in the event that they fail to make a second application within the period of 5 years, starting with the original grant of pre-settled status. So to take, for example, if someone was granted pre-settled status on the 1st of January 2018, that would expire on the 1st of January 2023. And we felt at the time that the withdrawal agreement provided for certain circumstances within which someone could lose their rights under the withdrawal agreement, and that could be, for example, a result of conduct under Article 20 that would merit deportation of that individual. But importantly, the withdrawal agreement didn't provide or didn't permit any additional conditions or limitations. So in essence, doesn't allow the country, in this case the UK, to impose additional circumstances within which an individual could lose their rights in the withdrawal agreement unless expressly permitted under the withdrawal agreement. And the possibility that someone would lose their rights as a result of a failure to make a second application is not provided for under the withdrawal agreement. Now, we raised our concerns with the Home Office, and at that time the Home Office did not agree with our interpretation, and therefore we felt the need to go to court to get clarity on the position. So that's what we did, and the High Court handed down its judgment in December 2022, and it agreed with the IMA, along with the interventions from the 3 million and the European Commission, that it was not permissible, it was not allowed for the element of the EUSS to withdraw or curtail the rights of holders of pre-settled status in the event that they fail to make a second application. And the other thing that the court then went on to talk about was how permanent residence would arrive, and it decided that permanent residence would arrive or accrue automatically on meeting the necessary conditions. And in very, very basic terms, that means living or residing here in the UK for a period of 5 years. But that's what the judgment said back in December 2022, and the Home Office confirmed that it would not be appealing that decision in the earlier part of this year. And then I'll now pass over to Pam, who will talk to you about what's happened since then.
Okay, thanks, Rhys. Yes, so at the IMA, we have been, as you'd expect, very interested in steps the Home Office have intended to take to implement the judgment. We've been engaging with the Home Office for several months now to seek clarity about how it will ensure the judgment is fully implemented, so that nobody will see their pre-settled status expire if they haven't made a further application for settled status. In the recent announcement, from the Home Office, we obviously welcome the commitment that no one will lose their pre-settled status for failing to make a second application. But to be honest, we remain concerned about the lack of detail about how those plans will work in practice. And this has made it difficult for us to offer any certainty to citizens with pre-settled status about how the judgment is going to affect them, as we've not yet been able to properly assess the measures the Home Office is adopting. We continue to request further detail from the Home Office in the main about how these measures will be implemented. For example, we're asking about plans for communication with pre-settled status holders, how the judgment will be implemented in practice, including as it will implement different groups of citizens, for more information about what support is available to citizens, and about what is likely to happen after the 2 years extension of pre-settled status, because of course we expect that not everybody will apply for settled status over that period. We intend to provide updates as we receive more detail from the Home Office. So we issued a statement recently to shortly after the announcement from the Home Office. We are planning to issue an initial question and answer document shortly based on the recent public announcement from the Home Office, and we expect to publish further updates in due course as more information becomes available. In addition to the matters I've mentioned around pre-settled status and the extension, of course, in the announcement, the Home Office also referred to their plans to take steps to automatically convert as many eligible pre-settled status holders as possible to settled status once they were eligible for it without those people needing to make a further application. They said that during 2024, automated checks of pre-settled status will establish their ongoing residence in the UK. We don't yet know how that will be implemented in practice, and so we don't yet know what the impact may be on citizens who currently hold pre-settled status, how they may be automatically upgraded to settled status, and what might happen to those individuals for whom the automated checks do not enable them to be automatically moved to settled status. So I think whilst we welcome the announcement that has come so far, there's an awful lot of information that we need in order to be able to assess the plans, but we recognise, more importantly, in some ways, it's very difficult, I'm sure, for citizens to understand the impact on them individually, and so we remain concerned about that. I'll stop there and hand back to you, Andrea.
Thank you, Pam. Thank you. I think you've covered a bit of this already, but could you share if you think the government's announcement as of now fully implements the judgment? And I think you've covered a bit of the IMA's plans going forward on this, but if there's anything else that you can share with people tonight, that would be great.
I'm happy to go first, Pam, and if you want to add anything afterwards, then please do so. I think as Pam kind of mentioned, the commitment provided by the Home Office that no one will lose rights as a result of a failure to make a second application is welcome. And I think in the short term, the extension of 2 years makes sure that from September 2023, which we believe is the first date at which certain holders of pre-settled status would kind of see their 5 years residence or kind of pre-settled status expire, that is very much welcome. I think, as Pam indicated, that however there is a lot to be figured out. There's a lot of detail that we need from the Home Office about how this will work in practice in terms of that extension to be satisfied that no one will lose rights and therefore it fully implements the judgment. And I think there's that secondary part of the judgment then, which talks about automatic accrual of permanent residence. I think that is something that we'll be looking at in a bit more, need a lot more detail on how that will be achieved. I think as part of the announcement, the Home Office have indicated steps being taken towards automatic upgrade to settled status, which will, I suppose, is directly relevant to this question of expiry of settled status, because if you are being upgraded, then inevitably that becomes less of a problem. But again, more details around that kind of process. That's what we're looking to get from the Home Office now, and we hope to get that detail in the very near future, and hopefully be able to kind of form a fuller assessment of our view whether the plans fully implement the judgment. And as Pam mentioned, our intention is to try and publish as much as possible, as quickly as possible about our assessment. I'm just picking up a couple of things on the chat though. Now I've kind of got the mic, as it were, that some people possibly struggle to hear my first part, so I apologise for that. And so I don't know whether there's a problem with my audio. So if people are struggling to hear me, then please let me know, and I'll try to sort that out.
Thank you. I think it is. It's coming through maybe a little bit lower at volume than everyone else. Thank you for that. Kezia, just in terms of the implementation, would be great to hear your views on that as well.
Yeah, sure. Well, as Rhys said, the 3 million was one of the interveners in the judgment, and we're considering at the moment whether or not we think that the proposals are sufficient, give sufficient implementation to the judgment and indeed to the withdrawal agreement. But as Pam and Rhys have both said, there's a lot that still remains unclear. There are a lot of questions. I know that a lot of you have questions, which is why you're here today. But what I can say is that we at the 3 million remain concerned in that we know that the judgment said that there needs to be no expiry and people need to not find themselves suddenly without leave if they don't apply to upgrade to settled status. And we are concerned that this proposal at the moment does seem to potentially just be the Home Office kicking the can down the road by 2 years by extending everybody's pre-settled status. It means that there is still a sense of insecurity for people, and then people will continue to have a lot of very valid legitimate questions, and while it's clear that this is the Home Office's way of buying themselves time to try and figure out how best to go about implementing the judgment in the longer term, what we're concerned about is the fact that it could well be individuals that end up bearing the cost for that. So, for example, one of the things that we're very concerned about is the fact that when somebody logs onto their View Improve onto the View Improve system with pre-settled status, it will continue, at the moment at least, to show a status expiry date. So we are worried about what would happen to people who are nearing the point at which their pre-settled status would be due to expire before it has been extended, if, for example, they're applying for a job, because I think it's fair to say that there's a very real risk that prospective employers would find that off-putting, and there's a very real risk that people will end up being discriminated against on the basis of what is essentially a false expiry date on their status. I'd also point out that we feel at the moment that there's been a lack of constructive engagement by the Home Office with us and other stakeholders on this issue, and we would really like to see a meaningful consultation with organisations working in the sector who have a wealth of experience and insight into the way that the EUSS affects people. Certainly not only the 3 million, there are many organisations, and I really would hope that as the design of the auto upgrade to settled status is thrashed out, that the Home Office does seek proper input from organisations working in the sector. Thanks.
Thank you, Kezia. So we've talked a bit about the implementation and what this looks like, but we've had many questions sent in advance to us on how this will work in practice. And we've grouped these under some main themes. So I'll hand over to Chris, who will talk us through these.
Thanks very much, Andrea. And as Andrea says, I'll attempt to sort of cover some of the questions that the Home Office announcement has thrown up. I think you've already heard that there are questions, lots of them still to be answered by the Home Office. And so what I will try to do is give information based on what we do know, and sometimes I'll be talking about what we still don't know in line with the other colleagues on the call, and where we hope to get more information sooner rather than later. So I'll look at the 2-year extension first, and then I'll talk about the automatic upgrade to settled status. So as Andrea said, people submitted questions in advance. So thanks to everyone who did that. I'll try and sort of drop a few names in there as I can. And I can see on the Q&A that they're the same types of questions that are being posted this evening as well. So I think that there's a lot of value in running through some of these details. So first of all, I think people are obviously clear that there is a 2-year extension coming for pre-settled status holders if they do not apply for settled status. And so the question that we've been asked is whether this will there be further 2-year extensions if people continue not to apply for settled status. So what will happen at the end of those 2 years? And I think it's fair to say at this point in time, we don't exactly know. I think, and Rhys will certainly dive in if I get anything wrong about the judgment here, but because the judgment says that pre-settled status holders who continue to reside in the UK under the conditions of the withdrawal agreement cannot lose their status because they don't apply for settled status, that would mean that in principle, the Home Office would have to continue to extend pre-settled status holders if they got to the end of the first 2-year extension. So I think the principle of the case says that the Home Office would have to apply further extensions if the person did not get settled status, but they could still show that they met the conditions of the withdrawal agreement. But I think, as Kezia pointed out, what the Home Office may be doing in this 2-year extension period is doing some more work to try to understand which people may no longer be living in the UK under the conditions of the withdrawal agreement, those people who may have broken their residence. The Home Office may be trying to understand more about that situation. Because there will be an automatic upgrade to settled status for some people, the Home Office will still encourage some people to apply for settled status when they qualify. And so potentially the idea is to reduce the number of people with pre-settled status so that the Home Office can potentially take more of a look at their situation. And so this is one of the sort of big unknowns. But so when we get to the end of these first 2-year extensions, we will have to understand more about what will happen at that stage. I think people in my position in the sort of advice sector would probably say, we think it's unlikely that the Home Office will continue to indefinitely just apply extensions to pre-settled status without engaging with the person who they're extending at some point down the line. It may not be for several years, but it seems unlikely that will be the ultimate resolution. But as we say, we'll have to see more about this when the Home Office announces it. And we've asked, I think the main complexity and the main questions that we've received, which show how confusing the situation can be for some people, is to do with the idea of whether the extensions will contribute to people's residency that allows them to build up towards settled status. Because obviously people will have lived in the UK for a period of time with pre-settled status, and if they are then granted an extra 2 years, the question is, or the question that we've received quite frequently is, well, does that count as part of my 5-year qualifying period for settled status? What if I had a period where I was away from the UK and then I've come back and then I've started to live here again and I'm now going to get an extra 2 years? Can I use this to build up to the 5 years that will then get me to qualify for settled status? It's not an easy question to answer simply, but the way that the settlement scheme works, which is to implement the withdrawal agreement, is to say that people have to begin their residency in the UK before the end of December 2020. So the last day to start residency was the 31st of December 2020. And once the end of 2020 passed, people weren't allowed to start a new period of residence under the withdrawal agreement or under the EU settlement scheme unless they are a family member who is coming to join someone who's sponsoring them. But I'm going to leave those family members to one side, because, as I say, they can come after the end of 2020. But for most people under the settlement scheme, they have to be resident by the end of 2020, and they have to keep their residence for 5 years until, like, have a period of 5 years of residence in the UK, and then they will qualify for settled status, or potentially they qualify for permanent residence under the withdrawal agreement after those 5 years. So if someone with pre-settled status has then spent a long period of time outside of the UK, and this was after 2020, so that like it could have begun before 2020, but they didn't come back before the end of 2020. If they've had a long period outside the UK, and then they've come back because they still have pre-settled status and carry on living here, and they're now going to be given an extra 2 years if they haven't applied for settled status, can that person say, well, even though I had a long absence, a long break, I can still build up 5 years of qualifying residence? And the answer will be, is if that long absence could not be justified, because some long absences can be justified, things like COVID-19 caused people to have long absences that can be justified. But if the long absence cannot be justified, and the person is considered to have broken their continuous residence, that's what we say, the sort of lawyer term for it is breaking your continuous residence. So the absence is too long and you've broken your connection to your residence that began before the end of 2020. If you break that residence, you cannot qualify for settled status, even if you come back after the end of 2020 and live here for 5 years with an extension to your pre-settled status. Because even though you may get your pre-settled status extended, the fact that you broke your residency after the end of 2020 and you did not start living back in the UK until after 2020 means that you cannot meet the condition of settled status, which is that you were resident before the end of 2020, because that's the key condition. And so all of these extensions to pre-settled status that could happen will never be able to change the fact that your residency was broken and you didn't start living in the UK until after the end of 2020. So that's the sort of difficult part of all this, because obviously people are going to receive extensions, but it may never help them to get to settled status in the end. And that's, again, why when we look at whether the Home Office will continue to extend pre-settled status grants, that's why we say that the Home Office will potentially start to look at whether people have broken their continuous residency at some point. The Home Office may in the future look at whether people have broken their continuous residency to see if that person can ever qualify for settled status. And if they can't, then the Home Office may stop extending their pre-settled status. This is my speculation, just to be clear. This is not something the Home Office has announced. As I say, so I think the key question, and I can see in a lot of the Q&A comments that people have put in, and when they say, well, these are my circumstances. I was here before the end of 2020, and then I had to leave because of COVID, wasn't able to stay, and then I came back in 2021 or maybe 2022. I'm trying to understand if I'm allowed to carry on with my extension to get to settled status. Hopefully for many people, the answer will be yes, because as I say, there was guidance about COVID being an exceptional scenario, allowed people to have a longer absence. There are other reasons why people may have some long absences that are also acceptable. Sometimes people study at overseas university. Sometimes they work overseas for a period of time and then come back. So there are, within the rules, there are situations where you can have longer absences, but they are quite, they are quite strict overall, the residency requirements. And so if you're not sure about your scenario, or if you think, well, I did have a long absence because of COVID, I better check this. It's a good idea that the 3 Million have done an excellent FAQ on what continuous residence looks like and how absences affect that. And obviously, you may want to speak to qualified advisors to understand, because they're really can be quite complicated rules, I'm afraid, for people to understand. Certainly a lot of the work I do is to working through people's residency situations where they've been away for a period to understand how it can impact on them. So that's how we sort of, what we probably want to say about how the extension will affect people. Some people will still be able to get to settled status. Some people, even if they do get an extension, are not necessarily going to be able to get to settled status if they're considered to have broken their residency after the end of 2020. We also have had some questions about whether the extension will come to pre-settled status holders who are currently awaiting an outcome of a settled status application, or potentially have been refused settled status in the past, or potentially someone who's been refused and is now looking to appeal or to make an administrative review. And again, we don't have anything in writing that we can point to from the Home Office on this, but our understanding is that pre-settled status, if it is coming up to that expiry date, will be extended, even if the person has a settled status application under consideration when that pre-settled status is coming up to expiry. So those people will be extended for 2 years, during which time, of course, the Home Office will be looking to process their settled status application. If someone has been with pre-settled status has been refused settled status because the Home Office says, well, you've broken your continuous residence, so we don't think you can build up the 5 years that's necessary for settled status. My view on that would be that's someone who the Home Office is saying, well, you're no longer covered by the withdrawal agreement because you don't have the residency, you've broken the residency conditions. And so in that scenario, I would think that in the legal principle to me would be that the Home Office could remove the person's settled status. They wouldn't necessarily have to extend it. Now, whether this will happen at this point in time, I think is, we don't know that. This is nothing the Home Office has said. They have simply said a blanket, their press release says, if someone's pre-settled status is coming up to expiry, we will issue a 2-year extension. So they haven't added any conditions to that in the press release, at least. So it may well be that even for people who have got a refusal of settled status because they broke their continuous residence, according to the Home Office, they may still get an extension of their pre-settled status at this point in time. Now, one thing that I would want to add to that is if you are someone who the Home Office has said, we're not giving you settled status because we think you didn't, we think you've broken your continuous residence, you certainly would want to talk that decision through with the lawyer to make sure that it's something that, well, you want to know if that's a challengeable decision. You want to know if it's the right decision for you, because it may be that there was some evidence that wasn't available in that particular application that you might have access to now. And so it's not necessarily something that couldn't be challenged. It's but at the moment, the Home Office would be saying, well, we're not going to give you settled status because we think you've broken your residency. So definitely something to look for advice from a lawyer if you have got that scenario, because obviously you would want to challenge that if at all possible. So that is that's the extension side of things. As I say, the main sort of questions we had on the extension side of things. The automatic upgrades to settled status, when that begins, we have a date of 2024. We don't have anything beyond that in terms of whether it would be the beginning, middle or end of 2024, but that's what the press release from the Home Office says. So I think we can digest from that there are still operational aspects of it that the Home Office is working through. And so what will they be doing to assess if people should be automatically upgraded to settled status? Now, for those who've gone through an application under the settlement scheme, pre-settled status, settled status, you'll know that when the application form, it asks for your national insurance number. And if you have one, and if you provide that in the application, there are some checks that the Home Office system will carry out to see if they can spot you as a UK resident. And what those national insurance number checks are, they're with the Department of Work and Pensions, they're with the HMRC, the tax office. And if you get a sort of hit, as they like to call it, on the from your national insurance number, then the Home Office says, well, we can see you were present in this month or over the course of this year, or sometimes over the course of these 5 years. And therefore, we think that you don't need to give us any more information or evidence about your residency, because we can grant you status based on the national insurance checks. Now, so we have to assume that this will form part of the automatic upgrade process, because it's already a system that works for the Home Office. there's probably a question about whether they might look to expand the checks, because that's not the only data that government would hold to see if people are resident. So it may be that there's other information that the Home Office will look to use to see if they can spot someone who's resident for 5 years who they can give an automatic settled status upgrade to. One of the questions asked about border information, about whether they might rely on border information. Don't know the answer to that question. There is obviously information gathered at the border. My experience of it when I've engaged with it for clients who I've worked with looking at travel data is it can be a little bit incomplete. And so it may not be an entirely reliable source of data for the border. So I don't know whether that's something that will be used. Again, these are the details that we would hope the Home Office will be providing us about the automatic upgrade. Another question about it is when and how frequently will the Home Office be checking the data, that whatever the data is that they are checking to see if someone is a resident here? How often will they do that for that person? Is it just once when they come to the end of their pre-settled status, or is it something that's run throughout their system on a more frequent basis? Again, not something that we can say. It seems to make it effective that it would be useful to run it on a relatively frequent basis to capture the moments where people do have that 5 years of residency that can be seen through the data. So, but again, more details to come on that. And then, of course, there's the flip side of automatically upgrading people to settled status, which what happens if I'm not automatically upgraded? Because as I've just kind of said, it relies on government data. Now, not everyone has that data to show that they've been resident for 5 years. And so what's going to happen to those people? Are they going to be told, for example, that they have been checked by the government system, but it cannot see 5 years? And so will the Home Office reach out and say, well, we'd like to understand your scenario a bit more? Or will they even know that an automatic check has taken place? These are good questions that are being provided to us, and not ones that I have a clear answer for at the moment, I'm afraid, because we just don't know. I'm not sure if the Home Office has decided on that at this point in time. So if you're someone who, I think that the key, or my position on it would be that anyone who isn't automatically seen by the automatic upgrade, the checks, the data checks, that doesn't really mean anything about their situation, except that they can't be automatically upgraded, because they may have plenty of evidence about their 5-year residence that can be provided to the Home Office, and they're equally eligible for settled status. It just probably means that they'll have to go through a different process to get there. But it's certainly not being automatically upgraded shouldn't be seen as a big negative against you. It just simply means, or in my mind, it would mean the Home Office doesn't have the data to understand whether you have been resident. And I think this is where I'm going to ask, because I'm sorry, I've done a lot of talking, I recognize that. I'm going to come back to perhaps Rhys, because one of the questions that we got about automatic upgrades was about whether the High Court ruling requires the Home Office to issue people automatic upgrades when if they introduce a system. Are they doing it because they're required to do it? Are they doing it because they sort of have a choice in the matter? And I think that there was also a follow-up question about is there a sort of discriminatory element perhaps to it, that not everyone will be able to be upgraded to settled status via this system? Hopefully that's not too much of a difficult one. I think you'll have a view.
No, not at all. Thanks, Chris, and thank you. Kind of found you kind of talk very interesting, and picked up a lot of things there. So, but in terms of your actual question, I think does the judgment require the Home Office to implement an automatic upgrade? I think that's a difficult question to give a straight answer to. I think in essence, what the withdrawal agreement provides is that persons who are eligible for permanent residence are able to enjoy the benefits that come with that, and that would include the ability to be out of the UK for more than 5 years. up to 5 years, sorry, for example. But I think, you know, what the withdrawal agreement makes clear is that the onus is on the individual to demonstrate that they meet those conditions. So, you know, what is required is that when that individual is who is entitled to permanent residence, who has accrued the relevant length of period within the UK to meet the conditions of permanent residence, where they have done so, that they're able to enjoy those rights. Now, you know, that there are various means through which the Home Office and other kind of public authorities could look to implement that, and you know, that's not necessarily for the IMA to dictate how they would do that, but certainly what we are interested in their decisions as to how they would look to ensure that those with permanent residence rights will be able to fully enjoy those rights. And as they announced in their plans recently, that part of that is to look to automatically upgrade, and you know, in one sense that is implementing the judgment so that those who are eligible are able to enjoy those permanent rights residence because they will hold settled status. But I suppose in terms of our assessment, you know, we are keen to understand the details for, and a lot of the reasons are those that you have talked about. You know, what data will be used, what circumstances do people get upgraded, what circumstances do they not, and kind of to interrogate that. And that's what we're interested in, because ultimately what we're interested in is identifying any areas of concern where people either fall out altogether for whatever reason, and making sure that where people are not enjoying rights, and there's a reason and a valid reason for that, and where people are not able to fully enjoy their rights are able to do that. So I think I'm not really answered your question. I think, unfortunately, but I think it does automatic upgrade implement the judgment. I think yes, in part. Does it fully implement the judgment? Remains to be seen, I think. But I think that there are other steps that could be taken to accompany that, to ensure, because it's not just that the Home Office that needs to implement the judgment, it's public authorities across the board, so that if someone does have permanent residence rights, that they are then entitled to the rights that they're provided with under the withdrawal agreement. So as well as the Home Office, that will be looking to ensure that it is implemented across the board.
Thanks, Rhys. I think if I can sort of jump on that and present like an example of this, which is quite a useful one, because as you say, it's when people have acquired permanent residency under the withdrawal agreement, they may not yet have settled status, because we know people don't have to necessarily apply for it. They may be upgraded at some point in the future, which might not even recognize the date that they became a permanent resident, because that can happen a lot earlier than someone is granted settled status. But I think what we've seen recently, and it is a Home Office implementation rather than another government department, but for those who are looking to become British nationals in the future, as people are entitled to do once they've lived in the UK for a period of time, this has been changed quite recently to say that pre-settled status holders can actually apply for nationality if they can prove that they've acquired permanent residency under the withdrawal agreement. So they wouldn't have to get settled status and then go and apply for nationality, which up until the judgment would have been how nationality law operated. So there's a sort of example that we can see where the Home Office has started to say, we can see it's not just about the settlement scheme, it's other areas that need to be addressed as well. And so I think that's a useful thing. But there are obviously loads of other areas where that will have to follow as well. I think I just to finally conclude the little bit that I was doing on the questions that we were submitted in advance. We had a really good and very sort of seems like an obvious question in this, but actually sometimes we have to step back and think about it and say, well, for those people who've seen all this announcement and think, oh, well, I could get extended, I could get an upgrade, but can I just apply for settled status? Is that something that I should do? And the simple answer to that is yes, by all means. If you have the 5 years of qualifying residence that you need for settled status, then you don't have to worry about anything to do with the automatic upgrades or what will happen in the future. You can make an application now, and many people have made applications. There's been many, the Home Office will talk about that. There's been something in the region of 500,000 upgrade grants, I believe, from pre-settled to settled status. So this is not something people have to wait for if they have those 5 years. I think we had a question where someone applied after 4 years and said, what happens to me? Because and you just jumped the gun a little bit. You just went a year early. So there's no reason why that person who applied after 4 years thinking that was it. Actually, if you wait another year, you can apply and get your settled status. And I think again, as Reece just said, it's like, because it's part of the judgment is confirming people's permanent residence rights. Once you have settled status, that is your indefinite right to reside in the UK. And so by all means, people can apply, and it's done in the same way as you applied for pre-settled status with that online application verifying your identity document. I think we're going to talk about the actual technical what you need to do, because there is a little bit of a glitch that we can see in the system. But yeah, it's a national insurance number, and if the Home Office will check it again, but you can also provide residency evidence over your 5 years. There's a link on the Home Office gov.uk website, which talks about the type of residency evidence that they would hope that people present with a settled status application. Someone did ask us in the written questions about how long it should take to process a settled status application. It's not one that you can sort of definitively give an answer to. Some of them will be pretty quick. Some of them might take a bit longer. The Home Office may have to engage with you about your residency evidence if they can't see it from the national insurance number. So we don't really say, oh, it should take this amount of time or this long. It's always a bit variable. But if you've made your application, then the Home Office will process it. So I'll draw there. Thanks for everyone for all those questions in advance, which allowed me to kind of bring out a few of the really interesting aspects of this. And back to you, Andrea.
Thank you, Chris. And we really hope that some of those main questions clarified a lot of things for many of you, including questions that we can see in the Q&A section. So I'm going to pick some that we haven't. I'm going to try to go with those topics that we haven't yet covered. So, for example, Sylvia asks on specifically pre-settled status, what does it cover in terms of benefit access, welfare access? And in one case, basically someone was told by a council that due to their pre-settled status, they had no right to either universal credit or housing help. Which rights, if any, are protected for people with pre-settled status whose marriages break down, and is the attempt to claim welfare, does it count against them in an application? I think this is also linked to the discussion you started on people who also have that period of 5 years of residency, so should be entitled to the permanent residency rights, as the High Court found, but they do not yet have proof of those rights through settled status.
Shall I try and start answering that, and then hand over to the rest of you? In terms of what pre-settled status holders are entitled to from a benefits point of view, you may already have encountered this, but there is an additional right to reside test that exists for pre-settled status holders, which means that they have to be able to demonstrate that they were exercising treaty or are exercising treaty rights, which isn't exclusively a evidence of work, but for most people what that means is that they have to also demonstrate that they're working in the UK. But something that is changing through these changes that have been brought in by this statement of changes is the fact that it acknowledges that somebody could have acquired a right of permanent residence while still having pre-settled status before they've actually gone on and acquired settled status. And so that might have an impact on somebody's ability to claim welfare support. So for example, to try and explain it more clearly, what that means is that somebody who may have been working in the UK, let's say, for 5 years previously, even though they're not working now, they would have acquired a right of permanent residence, but they might still just have pre-settled status because they haven't yet applied, or they may have applied for settled status and may just have not received a decision on that application yet. But if they can now demonstrate that they have previously exercised treaty rights for a period of 5 years, they can therefore demonstrate that they have acquired permanent residence, and they would therefore be able to go ahead and make an application for welfare support despite only having pre-settled status. But it's a complex area, and I would advise people to seek advice from specialist welfare advisors with regard to that. And in terms of the later question about whether or not having claimed benefits would adversely affect an application later on under the settlement scheme, no, it wouldn't. I think that that's fair to say. I turn over to Chris in case there's anything more specific that you could say.
No, I mean, I think I absolutely agree with all that, and particularly the point about claiming benefits is not a negative for applying for settled status, because that's based on your residence in the UK. I think there was just a little question about if rights are protected for pre-settled status holders whose marriages break down. This is quite a complicated area of the settlement scheme and the withdrawal agreement. If you're a sponsored family member, so if you're a European national who was resident in the UK by the end of 2020, then you have your own rights. But if you've been sponsored as a family member, perhaps you're not from the European Union, or if you have joined a sponsor here after the end of 2020, and if your marriage breaks down whilst you have pre-settled status, that can have significant impacts on your situation. Far too complicated, I'm afraid, to go through now. So we would always say seek specialist advice. It will have to be sort of a regulated advice at a certain level, because it's what's called under the scheme a retained rights of residence situation, and it is complicated. So that's just to add on the marriage breakdown situation, to try to get to speak to someone qualified to tell you what your position actually is.
Okay. Can I just jump in to acknowledge a comment that's also been made by Nicole Mousry, who's on the call, who is pointing out that in terms of whether or not somebody's claiming benefits could impact on their route to settlement, there's the possibility that it could affect Chen carers who are primary carers of self-sufficient EU children. I'll just add that as a caveat. Thanks, Nicole.
Thank you. So I'm going to go to Koda's question, who asks, if EU citizens were only required to make one application per the withdrawal agreement, but the Home Office didn't initially fulfill this by creating the two separate statuses, shouldn't those with pre-settled status be entitled to keep that status regardless if they get upgraded to settled status or not?
So I'm happy to go first with that one as it relates to the judgment. So I think what the judgment talks about is that you can't lose your rights by failing to make a second application. So that means if you've made an application, you have acquired that residence document, your status under EUSS, then you are entitled to rely on that. And I think the steps taken to extend pre-settled status is very much part of the Home Office's commitment following on from that decision that no one will lose rights as a result of failing to make that second application. However, what the withdrawal agreement does provide, as was the case in the EU law previously, is that you do have different categories of residence rights, if I can put it that bluntly. And you've got the pre-permanent right of residence, and you've got permanent right of residence. And to obtain permanent right of residence, you need to be able to meet certain conditions. And therefore, it is perfectly reasonable or perfectly permissible under the withdrawal agreement for there to be a process to ensure that individuals do meet those conditions are therefore entitled to those rights that accompany permanent residence rights. Now, in the UK, that has been implemented by way of the EUSS and specifically a PSS and settled status. So having those two statuses isn't necessarily a problem, because it reflects that kind of the permanent residence rights and the rights that kind of the pre-permanent residence rights. So I don't think that of itself is another problem. It is a problem. And I think there was another question from an anonymous attendee on the kind of same kind of topic, which I think Monique has already answered, which is about was it lawful to have PSS at all? Was it not illegal to have pre-settled status at all? And pointing to some of the decisions made in other member states where permanent residence was granted immediately. And I think the judgment wasn't about saying the pre-settled status of itself is illegal. That's not what the judgment was about. What the judgment was it was quite a focused issue that you cannot use your rights if you fail to make a second application. And what the Home Office have said, that if you are a holder of pre-settled status and you are approaching the expiry date of your original pre-settled status, or 5 years from the original grant, that will be extended by 2 years, and at that point you will be written to by the Home Office to indicate that is being extended. So that fulfills that part of the judgment, in part to ensure that you're not losing the right as a result of failing to make that second application.
I think if I could just add again in full agreement with what Reese has just said, but I think what we will potentially start, what we're trying to, or what we're in the beginning of seeing, is the Home Office working through those who hold pre-settled status to try to get them to try to understand whether they are people who should have settled status and permanent residence rights holders, and people who have no longer kept to the residence conditions. But as Reese has just said, the judgment means that the Home Office's job in that respect is challenging, because they cannot make people apply to the Home Office, to allow the Home Office to start that assessment, which was the case before the judgment. The judgment's pre-judgment, the Home Office said you have pre-settled status, you must apply for settled status before it expires so we can assess you. So the judgment removes that element of the Home Office making people apply. So that's why you see the Home Office encouraging people to apply. They're not making people apply, but they're encouraging you to apply because they want to carry out that assessment and give settled status. That's why will be an automatic process to see people who have got the 5 years, because it's not an application. So what we're seeing is at the beginning of the Home Office trying to work through pre-settled status holders whilst never making them make a second application, because that would be a breach of the judgment. But there are other mechanisms that can be used to try to understand the situation of pre-settled status holders just from that residency perspective, which is what the people who are resident for 5 years will get to settled status, the people who aren't may have their pre-settled status taken away. And so what we'll see is more details of that coming in the sort of future months and year and so on.
Thank you, Chris. We have quite a different question coming from Facebook. I'm an EU national and my non-EU dependent parents live in the UK on pre-settled status. If my parents are employed during these 5 years of pre-settled status, will it impact the settled status application positively or negatively? Is dependency on the EU national sponsor still required for the settled status application?
I'm happy to take this one. So if someone has arrived with a dependency requirement that has been proved in an application, or there was a period where it wasn't asked to be proved, but and the Home Office said, no, we accept that you're dependent without you having to give us evidence. If a person holds pre-settled status as a dependent relative of someone sponsoring them, the Home Office has it written into the settlement scheme rules that when that person looks to upgrade to settled status, that they do not have to reprove the fact that they are dependent on the sponsor that initially they did have to show they were dependent on. So once you have pre-settled status, the requirement to continue to be dependent actually falls away, and you will be able to acquire settled status without having to show that dependency again.
Thank you. Just another clarification on family members as well. Just to confirm, if a family member has come to the UK as a visitor without a permit, can they still apply to the EU settlement scheme based on the relationship to a relevant family member if they meet all of the dependency requirements?
Yeah, I think I can answer that in broad terms, bearing in mind that I'm not allowed to be giving out legal advice. Yes, basically the change in that I mentioned earlier would only mean that family members were prevented from making applications because by having their applications deemed invalid if they were illegal entrants, and that doesn't include visitors. So people who enter as visitors are still able to make applications.
I think we should just add again, agreed with Kezia's point. But what we have to be clear on. So the Home Office, when they look at joining family members, their expectation is that a joining family member will apply from outside the UK to join. That's why it has the word joining in the description, so that they're joining. So generally, the Home Office expects family members to either apply directly to the scheme for pre-settled or settled status if they can use the ID scanning app outside the UK. That's mainly for European family members, or for non-European family members, they can apply for something called a European EUSS family permit, EU settlement scheme family permit. The idea is you're doing the same thing. You're showing that you're a family member who qualifies to join a sponsor in the UK. So that's what the Home Office expects of people. However, some people not knowing about this have traveled to the UK and entered what we say under the visiting rules, because if you enter without a visa, like if you go through the e-gates as an EU national without a visa, you're entering under the visiting rules, because that's the only rules you can really enter through an e-gate without a visa. And then if you happen to find yourself here and you then are like, oh well, I'm intending to stay with my family member who can sponsor me under the settlement scheme, then yes, you're entitled to make an application whilst you're here, because the rules don't prevent you. But for those family members who are not here, the Home Office expects them to apply outside. And if they came to the UK border and said, I'm coming because I meet the joining family member conditions and I need to enter and make my application, there's a good chance that the border officer is going to refuse to allow the person to enter, because they're not permitted to enter for that purpose if they don't hold the permission. So just to be clear, like if you have a family member who happens to be here, they can apply here, but if you've got family members who can apply under the joining family member rules who are not in the UK, they are expected to apply for the correct permission and wait for that to be issued before they travel here. We just have to be sort of clear on that from the way the Home Office operates the border rules.
Thank you. On continuity of residence, we have a question about, does an absence of less than 6 months qualify for a long broken absence?
So my immediate instinct is yes. I mean, as in it doesn't break continuous residence. So the residency rules are to attempt to do it in a very short space of time is if you looked at your 5-year period of qualifying for settled status or for permanent residency, in your 5 years, you're supposed to be resident in the UK for at least 6 months in each of those 5 years, year 1, year 2, year 3, year 4. You're supposed to always be resident for 6 months. Other than that, you're allowed to be absent. So if you were in the UK for 7 months in each of your 5 years and you spent 5 months overseas, in that time, that would still be fine because you haven't gone over the 6 months. So that's the kind of general rule to follow. You are allowed an extended absence sometimes, so something that goes over that 6 months. If there had been no COVID, you would have been allowed one extended absence in your 5 years for a good reason. So something like working overseas for up to a year, you would have been allowed to do, but only once in your 5 years. Because of COVID, sometimes people are allowed more than one extended absence, but that's where it does start to get a little bit complicated and advice. But if someone approached me and said, I've lived in the UK for 5 years and I never went outside for more than 6 months in each of those individual 5 years, am I okay to get settled status? The answer is yes. You have maintained your continuous residency under that scenario.
Can I just add one final point to that, which is that it's important to bear in mind that it's 6 months within any given 12-month period. So it's not necessarily looking at a calendar year, but at any 12-month period, and there can be slight differences there. I just point to the fact that we've got an absence calculator on the 3 Millions website that should help you to figure out whether or not you've had more than the allowed number of absences. But of course, our first main point would be, again, if you're in any doubt, seek specialist legal advice.
And sorry, someone's added a clarification in. I'll read out that what the clarification question is. It says, if you were absent for 5 months, i.e. less than 6 months, came back to the UK, and then a few weeks later you left for 3 months because of COVID, would the COVID excuse cancel the 3-month absence? Yes, the way the rules are written, yes, that would. So you would have, if it was for COVID, it wouldn't be counted in addition to your 5 months because COVID is deemed as something that happened extra to the normal allowances. So you would not count the extra 3 months in that scenario. So the person only has 5 months and continues to be resident.
Thank you. I think we have time only for one more question. Let's see, on the validity requirement. So from 8th of August, this will be made first. Do you know what the process will be for this? So, for example, for someone who is reapplying after a first failed application.
Sorry, was that about validity? Yeah. Well, so there's always been a validity assessment within the application process. The difference is that some issues are now being moved into that category, whereas they were previously part of the kind of broader eligibility assessment. So, for example, in order to make a valid application, people are expected to provide a required form of ID. And if they are outside of the UK, when they're making their application, they're required to provide proof of their entitlement, which can be an EU passport, or if it's from a non-EU applicant, it could be having a residence card issued under EU law, for example. So those validity assessments have always taken place. It's just that now the consideration of the reasons why somebody's making a late application are also being lumped in there as part of the initial validity assessment. So there's nothing that would prevent somebody from making another application if they'd made an application previously that had been refused. But what I also want to emphasize is that the guidance on this hasn't been updated yet. And so we don't really know the ins and outs of exactly how the Home Office is going to treat applications where they deem an application, the lateness to be unjustified. But on the face of it, it would seem that there's nothing to prevent someone from making another application with further evidence. But we have to wait and see what the guidance says before we really can comment further. But I think Chris maybe wants to add something to that.
Yeah, sorry, I was just thinking, I mean, I think the way I see this change, and I think for those of us who sort of advise on this, the reason the Home Office is changing the approach is to make it more challenging for people to make late applications, because they think that there's too many people who have applied who are not eligible for status. So this is what this change in approach is about. If someone has an application that has been decided by the Home Office, and the Home Office says no, you're not entitled to status for whatever reason they give in the refusal letter. At the moment, because it's not the validity decision that Kezia was talking about, someone can just put the application back in and say, look at it again, I've given you more evidence perhaps. After the changes, when it becomes a validity decision, the Home Office may well take the approach that if someone has had a decision on an application that has already been made, they do not have a good reason to make another application because it's another late application. And so they are quite likely, I would imagine, we have to see the guidance, but it is a little hint of this in the existing guidance that they say, well, actually, it's not appropriate for you to come and make another late application because you don't have a good reason because, and what they may well say is, when you got your first refusal, you had an avenue to challenge that decision. You could have applied for an administrative review of that refusal decision. You could have gone to the appeal tribunal. So if you wanted to challenge this decision, the appropriate action to take was to do that. And so coming with another late application is not a good reason in our view for us to process it, and they might reject it on that basis. So if someone came to me if the changes take place on the 9th of August, so if they came to me on the 8th of August and said, I've been refused, or perhaps the 9th of August is better, I've been refused, I've got the right to challenge this by administrative review or appeal, or I can try to make another application, knowing that the validity rules have changed, I would most likely be telling them to use the appeal or the administrative review channel, because I wouldn't want them to get rejected by the Home Office for not being allowed to make a new application. And also because the time that will take, they may have lost their right to challenge using the administrative review or appeal. So I think it will change it's quite a big change from what we've seen so far, I think, with the Home Office.
And I think just to add to that as well, the questions around the process that will accompany this change in approach to considering the grounds for lateness of an application, and obviously the withdrawal will permits that assessment of to what extent is the lateness reasonable, and what reasons are there for that lateness. But that is an area where we are looking to get more information from the Home Office as to how exactly will it operate in practice. So we are expecting hopefully some more information on that. But as has been mentioned by some of the other panelists already, that there is the guidance that is the expansion memorandum to the statement of changes. So the rules that were kind of laid does make reference to guidance being updated on the government.uk website at the time that these changes take effect, and we would assume that one of those guidance documents will relate to this area. So that'll set out a bit more detail. So as with anything, there's a little bit of detail to just kind of to think through to find out from the Home Office. And I think as Pam mentioned earlier on, that we'll be looking to publish a bit more from the IMA perspective in relation to these reforms that have been announced in the 7th of July, in addition to those that relate to the judgment.
Thank you. Thank you, Liz, and thank you everyone on the panel for those really thorough answers. We have about 4 minutes left, and as we've mentioned already, you can also get in touch with us with your specific questions and find our main Q&A document on the repercussions of and the implementation of the High Court judgment. It's the link in the chat, and also keep an eye out for the Q&A document that the IMA is going to publish as well. But as I just want to reiterate that we do strongly recommend for people to continue to apply for settled status as soon as you've had 5 years of continuous residency, and take the last few minutes to share with you. We want to draw attention to a common pitfall that we've seen people falling under while doing that second application. So I'll share a video which shows you the application process and how how that can go basically go wrong if you're not careful in the user journey through the Home Office website.
It has been now 5 years since I'm living here in the UK, and it's now time to switch my pre-settled status to settled. And let's see how that works. I'll go to the gov.uk website. Switch from pre-settled to settled status. I'll start now. And I have 2 options, prove my identity or sign in. But since I've proven my identity before, I'll sign in. I'll use my passport. I'm in. I have here 2 applications because I had one application rejected and the other one, it was granted status. So, but there's no indication of which one I was granted and which one it was rejected. But I'll just assume that it was my last one that I had status, that I have now status. So I will go and provide requested evidence. I will also just double check on my previous application just to make sure that this is not the right one. But it seems like I can upload evidence on this application as well, even though I'm quite sure that I was rejected status on this application. Even if I add residence evidence to either one of these applications, nothing will happen to it. No one will look at it because they are already decided. Instead, you should go to your phone and download the EUSS ID document check app. And start a brand new application.
I used to work 9 to 5, but what made me a millionaire was working a few minutes every day.
Oh, sorry about that. Oh.
maybe just while Andrea's muting that video, I can just say that that's something that we've come across time and time again, that people have, in trying to upgrade to settled status, have ended up adding evidence to their pre-existing application for pre-settled status. And it's really important that you know not to do that, because nobody in the Home Office is going to look at that evidence, as I think was made clear in the video. So please make sure that you do go through and set up a new application, which means you have to provide evidence of your identity all over again, even though it may seem counterintuitive. And even if you've received a letter from the Home Office telling you otherwise, there's some misinformation out there. Okay, well, I think we're just about out of time. I think Andrea's having some issues with her audio again. So I think I'll just say, on behalf of all of us here at the 3 Million, thank you very much to Rhys and Pam and Chris for joining us today. And we hope that between us, we've been able to answer some of the questions that you've got. But please don't hesitate to get in touch with us at the 3 Million, at info@the3million.org.uk if you've got any other questions or issues that you'd like to raise. If you've got problems with your status or with the application process, please also report it to us, because it's really information that we need in order to do our advocacy work. Go to our report it tool on the website. Please also communicate any issues that you're having with the IMA. They have a tool as well, and are very eager to hear from people who are having direct experience of the processes. So please do reach out to them. And also don't forget to contact your MP as well if you're having issues. And of course, there's also the Home Office Resolution Centre that should be able to assist you. But please do get in touch. And finally, of course, seek immigration advice if you're in any doubt, because these are really important issues. And thanks very much for joining us here today. Please share the recording when it's sent out with anyone that you think might benefit from it. Thanks very much, everyone.
Thank you.
She's back.